Hello and welcome to Williams Mullins Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Courtney Reigel, and today I'll be joined by Carmelle Alipio, a fellow associate in our intellectual property practice group here at Williams Mullins. Carmelle has drafted data privacy policies and has otherwise assisted businesses with their data privacy compliance. We've also provided updates regarding state data privacy laws in the past, as well as FTC enforcement as it relates to data privacy. And today we wanted to provide an overview for listeners on updates regarding state data privacy laws and just kind of where we are now as we enter the new year in 2024. So Carmelle, thank you for joining me today.
Glad to be here and navigate through these privacy laws with you. The state privacy landscape has gotten much wider over the last years, hasn't it?
Yes. So we started off kind of in 2018 with California passing the CCPA. And since then, we still do not have a federal comprehensive data privacy law. So we continue to monitor the state data privacy laws that are being passed. And as Carmelle mentioned, 2023 was another big year for data privacy. At the start of the year, the Virginia Consumer Data Protection Act became effective. On July 1st, 2023, both the Connecticut Data Privacy Act and Colorado's data privacy law went into effect. And then just a few weeks ago, on December 31st, 2023, Utah's data privacy law became effective. Carmelle, can you start us off by providing an overview of some of the new data privacy laws that were passed last year?
Sure. In 2023, 8 states enacted comprehensive consumer data privacy laws: Delaware, Florida, Indiana, Iowa, Montana, Oregon, Tennessee, and Texas. Now, these state laws are pretty similar to existing data privacy laws already, such as the CCPA and Virginia's Consumer Data Protection Act, the CDPA, which some listeners may already be familiar with. For this year, Texas, Oregon, Florida, and Montana's laws come into effect. Texas, Oregon, and Florida laws are effective on July 1st, and Montana's Consumer Data Privacy Act will take effect on October 1st. Looking forward a little, Delaware's law will become effective on January 1st, 2025, Iowa and Tennessee's laws on July 1st, 2025, and Indiana's law on January 1st, 2026. Our listeners are probably interested in which laws will apply to their companies or their clients' companies. In terms of applicability, most of the laws have a broader approach. The most common applicability involves the amount of consumers whose data is controlled or processed by that business. So businesses that conduct business in the specific state or produce products or services targeted to residents of that state will likely need to consider the amount of consumers potentially involved. Another approach is by revenue. This is where annual revenue thresholds come into play, as well as percentages of the amount of gross revenue attributable from selling personal data. I'll note that this does differ from Utah's law, which, as Courtney mentioned, came into effect at the end of last year. Utah's applicability is similar in scope to Virginia's CDPA, but has a $25 million floor, which the VCDPA does not. So for the states that are going to become effective in 2024, Texas, Oregon, and Montana, and Florida, I'll take each of those individually. Let's start off with Texas. Everything is bigger in Texas, as we all know. So Texas's law will unsurprisingly broadly apply to most businesses. There is a carve-out for small businesses as defined by the U.S. Small Business Administration, but entities doing business in Texas and process or sell personal data that are not small businesses will need to comply. Next up is Oregon. In Oregon, and also Indiana and Iowa, the laws will apply to businesses that control or process the personal data of at least 100,000 residents, or at least 25,000 residents if deriving 50% or 25% specific to Oregon or more of annual revenue from selling personal data. We'll note that 100,000 threshold number is also used by several other data privacy laws already in effect, including Virginia, Colorado, and Connecticut. Next up, we have Florida. Florida's requirements are similar to Utah in that fewer businesses will likely fall under its thresholds. Florida's law will apply to entities that have an annual global revenue of more than $1 billion and one of three other criteria that focus on online sale ad revenue, consumer smart speaker and voice command services, and application or digital platforms. Finally, I'll hit on Montana. Montana's law will apply to businesses that control or process the personal data of at least 50,000 residents or at least 25,000 residents if deriving 25% or more of their annual revenue from selling personal data.
Thanks, Carmelle. So businesses really need to be aware of the number of residents whose personal data they are collecting, especially if there's any states where they're hitting 100,000 residents or if they are selling a certain amount of personal data as part of their business model. In terms of exemptions, I know that some existing state data privacy laws do not apply to nonprofits, colleges, or universities, or other certain organizations. When we're looking at the new data privacy laws that were passed last year and that are going to become effective in 2024, do those include similar exemptions?
Generally, yes, but the exemptions are not identical across those new laws. For example, like Colorado's data privacy law that's already effective, the Oregon Privacy Act does not explicitly exempt all nonprofits. So businesses should carefully review the exemptions that are provided under each law, as some of those state exemptions for any businesses that already must comply with other state laws that relate to data privacy or security, such as the Graham-Leach-Bliley Act. While those other state laws only include exemptions for certain information that is already subject to those other laws and don't include the business entirely from needing to comply with the law. So overall, we are seeing a lot of overlap in the new state data privacy laws, but of course, every case is different.
Yeah, so the overlap should be helpful for businesses in developing their data privacy compliance programs, but it's going to be important for them to understand differences in the laws. So one obligation that is going to be the same for all existing and new state data privacy laws is the requirement that businesses post a privacy policy. What is actually going to be required to be included in those privacy policies is going to change depending on the state law. Something else that the new data privacy laws are requiring, and that actually wasn't something that was included in California's kind of original CCPA, is that certain covered businesses are going to need to conduct data protection assessments, and sometimes these are going to be required annually. I believe that Utah and Iowa are the outliers on not requiring those under their laws. So businesses need to be aware of whether they need to conduct and keep records of these assessments and what information is actually going to be required for these assessments under certain state laws. The state data privacy laws that were passed in 2023 also join Virginia, Colorado, and Connecticut in requiring opt-in consent by consumers in order for the covered businesses to process sensitive personal data. The definition of sensitive data changes depending on the law, but it's typically going to relate to consumers' racial or ethnic background, national origin, religious beliefs, mental or physical health conditions, sexual orientation, or includes children's personal data. The opt-in requirement means that just providing information regarding a business's collection of this information in a privacy policy or providing options to opt out is not enough. The consumer actually needs to opt in and provide consent for a business to collect and process the sensitive personal data. The only law passed in 2023 that does not require opt-in consent for sensitive personal data is Iowa. So across the board, the new data privacy laws and existing data privacy laws include additional requirements for processing children's information under age 13. This is something big that we want to mention because there's also other laws such as the Federal Children's Online Privacy Protection Rule, or COPPA, that applies to children's information as well. And this has been a focus of enforcement for state attorneys general as well as the FTC. So it's something that's really important for businesses to stay aware of. Most state data privacy laws also require businesses to disclose not only whether they sell consumers' personal data, but whether they process personal data for purposes of targeted advertising, and also how consumers can opt out of that type of processing. Texas and Florida will also require specific notices if a covered business sells sensitive personal data or by biometric personal information. So Carmelle, the new state data privacy laws also include similar consumer rights. These are the different types of requests that consumers in certain states can actually submit to the businesses. Can you touch on those a bit?
Sure. So under the new state data privacy laws, covered businesses must provide notice to consumers of their ability to access their personal data, correct their personal data. They will note that that right to correct is not explicitly provided under Iowa or Utah's law. Businesses also have to notify consumers of their ability to have the business delete their personal data. And as you briefly touched on, businesses will need to provide notice that consumers may opt out of the sale of their personal data. Some additional rights that these laws have provided to consumers include allowing consumers to have their personal data provided to them or transferred to another business. Well, we've seen that in the portability, right? And businesses need to provide information about how consumers can exercise these rights and submit their requests to the business. And they'll also need to actually take action on those requests. Some laws have specific timing requirements for when they need to comply with the consumer.
So that's, yeah, again, important for businesses to understand which requests they need to make available depending on the applicability of these state data privacy laws. And that will also be one of those things that need to go into your privacy policy if that's how you're providing notice to consumers about the requests that you're offering them. So one final thing I wanted to highlight for listeners on the new data privacy laws before briefly touching on enforcement updates is the private right of action and right to cure. So when California passed the CCPA, that law included a private right of action. It was limited for consumers whose personal data was the subject of a data breach by a covered business that did not implement reasonable security measures. Other state data privacy laws that are already effective, Virginia, Connecticut, Colorado, and Utah, do not actually include a private right of action. So are the new laws that we saw passed in 2023 and that will become effective this year, do those include a private right of action?
The state data privacy laws passed last year all also do not have a private right of action. Additionally, most state laws include a cure period where covered businesses will have the opportunity to cure any violations brought to their attention by the relevant enforcement entity. Typically, the state's attorney general, some states have a specific data privacy enforcement agency. Curing a violation may include a business updating its privacy policy so that it's accurate, up to date, and includes all required notices and disclosures. The outliers that do not have a cure period are Florida and California. The cure provisions under California's CCPA and CPRA expired at the beginning of 2023. In Connecticut and Colorado, the cure period is also only temporary and set to expire 1 year after the laws have become effective.
Right, so important for in the states where there is a cure period available for businesses that receive any type of notification from the relevant enforcement agencies to take action within those cure period deadlines, because there is the potential that they could remedy any issues and avoid costly fines. And I think that will wrap our summary on the new data privacy laws. And I just wanted to quickly mention an update regarding enforcement of California's data privacy law. So the California Privacy Protection Agency, which was created to enforce the CCPA and CPRA, are also responsible for promulgating rules to enforce those laws. Those rules are open to the typical public comment period and rulemaking process. And rules for enforcing the CPRA were set to become enforceable on July 1st, 2023. However, a court decision by the Sacramento County Superior Court in June 2023 on a complaint filed by the California Chamber of Commerce pushed enforcement of the CPRA regulations from July 1st, 2023 to March 29th, 2024. So just a reminder for businesses and for those listeners with clients who might be subject to the CPRA that in addition to the text of the law itself, there will also be these rules that will become enforceable in a few short months that you need to be aware of as well. I believe that will conclude our discussion on state data privacy law updates today and what listeners should be keeping in mind as we start off 2024. Thank you again, Carmelle, for joining me and providing this information to listeners of Trending Now, an IP podcast. Listeners, if you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find more about our team, as well as past episodes of this podcast, as well as legal alerts. Please be sure to subscribe to this podcast to be notified when our next episode posts. Thank you again for listening, and until next time.